Good afternoon, everyone. This is the first VRT of 2022, titled PPLI versus Family Offices. I'm Zach Lucas, partner with Spencer West, and I'll be the one that's sort of running through this with our panelists today. Now, for today's session, I'm very grateful to be joined by Wong Lee, who's Managing Director and Head of Family Services at Lombard Odier, based in Singapore. Also very happy to be joined by Roger Chi and Yannick Hani, both of 1291 respectively, one based, Yannick, in Hong Kong, and Roger nominally based in Singapore. And then finally, we've got Michael Velton, tax partner with Deloitte, again based in Singapore. So going on to today's session, I'll run through the basic introduction on the topic of comparing these two solutions. And then we'll go on to run through the comparative assessment, looking at it from a client's perspective. We'll then end the session with looking at the combination structures. So looking at a PPLI in combination with a family office, and likewise family office in combination with a PPLI. Some of this is a bit counterintuitive, but when we do the analysis, you'll see that actually it reveals some quite interesting variations for clients. And finally, if we have any time at the end, we'll do question and answers. Generally, it'll take about an hour, maybe a little bit longer for us to work our way through this. The same admonitions as before when we did the VRTs previously. It's not designed as legal advice, certainly not designed as a sort of training platform. This is the bunch of practitioners having a chat around topical issues and giving their fair advice. So it may, we don't make any assertion that it's error-free. We would hope, obviously, to be completely accurate in what we're talking about at all times. Okay, so the introduction on the comparative assessment. Now, we're trying to adopt an approach where we're looking very client-centric. So the issues that we're going to raise are quite practical. So we're not going to be looking at the technical manifestations of both of these solutions. So we're working on the basis that some of the viewers, some of the people that have joined us today are going to be involved in client meetings where these issues will come up. Cost, consolidation, control, privacy, migration, asset protection, reversibility, and succession. So it's very, very grounded in the practical side of advising clients. And I think that's where we'll do most of the comparisons today. We'll end it with a summary of which we feel is the sort of better solution. I don't think that necessarily that's going to be an accurate or a truthful one, because as the sort of panel will go through, there are different variations depending on the type of clients that we're dealing with. So there's a market difference between, let's say, an extended family from Indonesia with multi-branches, multi-generation, as against the North Asian Chinese family that's a nuclear family with husband, wife, and a child. So I think the product fit will move around a little bit, so it's not definitive, but we're trying to do a baseline for this so that we can have sort of other discussions around how to remedy some of the deficiencies that we'll pick up during the analysis. So again, quite pictorial, so we'll do diagrams for this. This will be the representation of a classical PPLI policy. You've got the policy holder on top, life assured on the side. You've got the beneficiaries of the policy, and then we're assuming in each case that we've got an investment company that's been inserted into the policy that holds financial accounts. Now, likewise, we're going to adopt the classical Singapore single family office structure as an illustration. So you'll have a holding company, and then you'll have underlying affiliate companies, management, and a fund company. And then underneath the fund company, we will have the financial accounts, the investment accounts. So these will be the two side by side, PPLI and the family office, as we run through the analysis part. So to start off, we'll look at the cost aspect. And this is obviously working through, as if we were discussing with a client, what are the cost advantages to each. We'll look at the setup costs. We'll also look at the tax and regulatory costs, and then finally end out on what are the ongoing costs. Now, I think I'll probably kick off with Yannick on this to talk through from a PPLI policy perspective, are there going to be any effective minimums when we talk about the setup cost to access a PPLI policy? And that could be from a practical standpoint as well as from a legal standpoint.
Yeah, thanks a lot, Zach, and I'm happy to give some inputs on the cost side here with the PPLI. Obviously, the PPLI cost is very simply set up. Typically, there is a setup cost and there is an ongoing cost or kind of an administration cost. Plus, there are, depending on how much death benefit is insured within the policy, there would also be mortality costs. But this is kind of a separate topic, which is obviously very based on your age, your health status, and how much death benefit is insured. But just for the structure itself, the setup and the ongoing cost, typically they're in a percentage of the premium paid in, and then the ongoing of the net asset value. So you ask, okay, from what amount does it make sense? To be honest, it depends very much on the jurisdiction where you're coming from and why you need it. If you do a tax versus or tax benefit versus cost analysis, then obviously it's very different if you do that in the US, where you potentially have high tax, especially if you're in a state which has also state tax, like California. Obviously, your marginal income tax rate can go up to maybe 50% or even over 50%. So it's a very different view on if you pay now 50, 60, 70 basis points maybe for the solution compared to maybe the tax benefit that you're doing. In other jurisdictions where you maybe have lower taxation, it maybe makes less sense. And therefore, we don't usually say, oh, there is a minimum, typically say from private banking minimums, it makes obviously sense to look at it, but then it really depends from client to jurisdiction whether it makes sense or not.
Roger, just from your perspective, what do we see as the minimums coming through in terms of the setup, the minimum investments? Does it make sense for a client to engage on a PPLI at, let's say, less than 5 million, or what do we see at the sort of minimum levels?
Yeah, Zach, that's a very good question. So typically we do see it starting about the 5 million mark, but we have done policies that are smaller. We have done policies as small as 2 and 3 million. So, and as Yannick said, it just depends on the jurisdiction, depends on the different cost savings. And sometimes, for even these smaller policies, even though there may be a higher in terms of percentage setup cost, it does make sense, right? It does make financial sense.
Right. Okay, I think, Michael, from your perspective, looking at the tax side of this, and we one of the central themes through this is that we'll try and do a broad comparison between, let's say, an Indonesian based client, tax resident, to tax resident in mainland China. Obviously, PPLIs are typically promoted as a tax deferral mechanism or a way in which you can avoid having the income tax effect. From that perspective, what do we actually see from the Indonesia side, omnibus law, and then from the China side going forward? Do we still have that tax deferral aspect to the PPLI?
Yeah, I mean, from an Indonesian perspective, insurance policies are not viewed to be an investment in a controlled foreign corporation or CFC. So you then would have deferral until there's a partial redemption or full redemption. And that sort of position, I mean, there had been an exemption irrespective going up to a year or two ago, but more recent tax law changes have removed that, so that if there is a redemption, partial redemption, that would be taxed. But yes, deferral at that point. For other jurisdictions, it's really the same sort of question, right? I mean, how's the policy viewed? Are there accruals rules? Can it be caught by a CFC? Can the policy be caught by a CFC rule? But also more fundamental, does it actually fall within the tax base? In some jurisdictions, they define the sort of personal income, the investment income that might be subject to tax. But, you would expect, and there is some uncertainty. You mentioned China, there's a little bit of uncertainty potentially, but, you would expect, taxation when there is a realization typically for most jurisdictions.
Right, so you're still getting the tax deferral on that, but if we look at the family office and flip it over, there are some discussions around. I don't know if this is going to be the case with the upcoming budget, but there are some discussions around the minimum amounts investable going up for Singapore single family office. Obviously, we have the 13x, or what used to be the 13x, at the 50 million mark going in. But what's your take on that as part of the sort of mutterings around the setup costs on family offices?
I mean, just kind of picking up on the CFC point first. I mean, to the extent that the owners are still residents, in the home country, and there's CFC rules. I mean, you are invested in a company, and your diagram is the holding company. If you took out the holding company, you'd still be invested in a company, right? So to the extent that a jurisdiction has CFC rules, usually fair to assume that it's going to be sort of caught. And Indonesia, obviously, pardon me, has CFC rules. Yeah. So you would expect it to be caught to the extent that you've got Indonesian residents owning that. And bearing in mind what CFC rules really are, I mean, they're essentially anti-deferral rules. So rather than being able to accumulate income in the fund entity, in your example, and only be paying tax when there's a distribution, when there's a dividend, you're taxing it on an annual basis, on a quarterly basis. So CFC rules become important. I mean, you mentioned China as well. I mean, just as a point of contrast, China 2020 did introduce changes to the personal income tax, including CFC rules. They don't seem to yet have been implemented, but that's certainly something to watch. Other jurisdictions are going down that same path in terms of implementing CFC rules. Taiwan, I think, is perhaps the next, or the next cab off the rank, if you like, in terms of expected effective date in 2023. But you're right in terms of, to the extent that this is a Singapore structure, from a tax perspective, at least, ignoring the home country considerations, if the family's still resident there, Singapore, relies on being able to qualify for one of the resident fund exemption schemes, 13R, 13X, albeit that they've been renumbered, but let's kind of keep with 13R, 13X, because I still remember those. 13X, obviously you need to have an investment of $50 million to qualify for that. 13R, there hasn't been a minimum sort of to date. Yeah. Albeit that, to the extent that, with the management company, the family office, I think you've kind of described it as a corporate fund manager, to the extent that you're looking to secure employment passes through that vehicle, you would expect to have a level, a reasonable level of assets that are going to be managed in order to sort of support that employment pass. Yeah, I mean, do you think that we're likely to see changes to what was the 13R requirement for minimum investable amounts, making it maybe 20 million, something like that? To be honest, I think we just need to wait till next month and see. I mean, clearly, there's a whole bunch of policy issues that, are under consideration. I think all of us have read the reports around sort of, wealth taxes and, and within that, not just wealth taxes understood, but, how do you look to sort of raise further revenue from sort of, wealthier families, be that property taxes, etc. So you could see that would be part of, that would be one aspect of those sort of measures. But I think we just need to wait to the budget next month. I think just that neatly goes into the regulatory aspects of this. Certainly from Yannick and Roger, you can jump in on this. From a PPLI policy perspective, we don't seem to have a sort of regulatory imposed minimum of cost involved with the PPLI. Is that fair? Yeah, I mean, there's no regulatory minimums. I think it's up to the carriers, and it just depends on the minimum amounts that they invest in. But I think in general, the PPLI structures, they're very cost efficient. It's always under 1%, and they're very effective structures, and I think they're very good value because of that. Yeah. And just flipping back to Michael, just on coming back to this minimum spend on the single family office. That is a regulatory requirement if you're going to maintain your status. So that's typically at 200,000 per year. Do we expect any changes to that? No, I mean, I don't anticipate changes to that. And you're right. I mean, the condition for is that you have to have 200,000 minimum spend. But I don't expect a change for that. I mean, one point that sort of can get overlooked a little bit with that is that there is a focus on the minimum spend. But when you look at the conditions, to 13R, for instance, there is a requirement that related party transactions be on an arm's length basis. So, in a lot of cases, you would have a fee that kind of covers the salary of the employees, the family members, and at least a minimum of $200,000. I mean, strictly speaking, you really need to look at the activities that are performed by the fund manager from a transfer pricing lens and sort of determine, applying those principles, what an arm's length fee would be. But in terms of cost stack, you're right. I mean, that fee, whatever that fee comes in, the $200,000 or more, whatever that might be, less the salaries, less the other expenses, would then be subject to Singapore Corporate Tax Act, the 17% tax rate.
Right. Okay, I think just switching over to Wong Lee, looking at this whole discussion around costs, and when we sit down with clients and go through it, what do you feel is the some of the lessons learned particularly for some of the wealth planners that may be watching, and some of the maybe they're quite junior, they're just finding their way. What are the main things that we see coming up that may be missed in all of this discussion? And when you're rushing, because my personal view is it seems to be quite an over obsessive discussion around 13X, 13R, and if you're dealing with the family office, to the exception of everything else. But what sort of advice would you give from a practical standpoint for the for the folks watching?
Okay, so I think for me, these two, for want of a better description, solutions, PPLI and family office, they are great solutions in their own right. But for me, I think it's important, we've mentioned earlier about client intentions and objectives, to clearly understand what the client is trying to do and then match the right tool with the intended objective of the client. If you look at PPLI, as Yannick has mentioned earlier and Michael has explained in detail regarding the tax piece, personally from experience, I find that PPLI is a very good solution when there is a tax driver. When the client is in a situation where tax deferral is important, there are some tax planning aspects around the solution that we're looking for, then PPLI is a good consideration. The family office, on the other hand, in its true form, is meant to be an office that helps to manage, consolidate assets for the family in the longer run, transgenerational planning to some extent. So the purpose why we use a family office very often is quite different from the driver for the PPLI. And now that when we look at the two solutions together, from a cost perspective, as you say, if we look at the setup, we have the 13R and we have the 13X. So 13R has no minimum. So let's say if you have a client who's looking at putting 10 million into something, and then you have a wealth planner who has these two very popular solutions that everybody's talking about. Personally, if they rushed into a family office with the 10 million just because 13R has no minimum, I would struggle a little bit with it, because I think the wealth planner needs to think through and discuss with the client to say, what is your main driver? Is it immigration? Do you have longer term plans to build a proper family office? Because when you look at the setup cost for the family office, you have to employ an advisor like Michael. So, depending on whether we're using Deloitte, PwC, BDO, or whoever, the range could be anything from 20, 30,000 to a 6-figure advisory fee. And then you have the incorporation cost for the vehicles you're going to use. So it's not necessarily cheap depending on how you put it together. That's being one. So if they're only looking at getting an employment pass and they have no real long-term plan, I think as a wealth planner, as a proper advisor, you do need to drill it down with the clients a little bit. On the other hand, if you have a client actually with sort of a good to have to an employment pass, and then there is a tax angle to it, when you look at the amount, so we're talking about 13R, if it's again 10 million, then the setup cost for the PPLI, as Roger's mentioned just now, is usually below 1%. Arguably, if let's say we manage to bargain with 1291 for a 0.5% fee, maybe your setup cost may be level to the setup cost for the family office, but your ongoing cost with the 200,000 business spend, the family office will be more expensive.
Yeah, I think that's an interesting one.
You get what I'm saying? So if you start to look at the scenario, if you're looking at 200 million family office, then your PPLI cost from a setup perspective is not necessarily cheaper than you have to do a massive bargaining to bring it to a level which is sensible. So I think, we have the experts here who is going to advise us in relation to the technical pieces, but as the gatekeeper to some extent, where you're bringing solutions and you're bringing experts to the table, then as the wealth planner, it is your job then to have a proper conversation with the client to map the scenario properly to make sure that you have a sensible comparison with what makes sense.
Yeah, I think that's a good
my
point.
take.
I think what's come through is that the cost on the family office at least is fairly static, but the cost from a PPLI perspective is going to be on a percentage AUM basis. So that's
But having said that, I'm going to bring back to Yannick's point in relation to, because he did do a good comparison in relation to the cost of the solution versus the tax that you save. So if the driver is a tax saving driver, then that comparison will make total sense. So even if it's way off the charts more expensive than the family office solution, it will still be a sensible solution because of the tax that you save. So I think that discussion really needs to be a multifaceted one.
Yeah. So in your experience,
just so one quick point on that. I mean, to the extent that I mean, the driver is residency, you know, in Singapore, you're then resident in Singapore. You're no longer resident in Indonesia, so the CFC rules don't apply. You're no longer resident in China or Taiwan or wherever. So that kind of pointing, that comparison changes if establishing the structure is going to lead to tax residency in Singapore, for instance, and just Singapore.
I mean, just as a practical point, how many advisors do we see actually running those computations? I know it's quite rare, I would have thought, to have both of them lined up, both solutions at the same time, but even looking at that cost analysis, looking at the tax saving, looking at, you know, going through the ongoing cost per year and what it looks like in terms of fluctuations, is that something that is typical in the market that sort of wealth planners are doing, or is it we're really looking at the tax deferral and actually the costs slightly buried away? I mean, what's been the experience?
Personally, I don't see many planners putting these two together and properly analyzing it. I don't know about Yannick and you know, Michael's side, whether you have planners coming up to ask you questions of this nature.
Right. Guys, anything on that? Practical manifestations of this type of analysis? Is it typical?
I mean, to the extent that you're looking to obtain residency elsewhere, a residency in Singapore, you know, that piece is kind of a bit easier. The harder piece is, what does it mean to cease to be resident elsewhere? And that can be kind of a more, you know, it's there's a sort of the technical rules, and then there's the practical requirements in order to sort of break residency. So you do see a fair bit of work going into that, to the extent that, you know, you want to achieve just tax residency with the family office.
Okay, I think the key takeaway from this one is the tax deferral aspect. I think that's the key bit that comes out from, obviously the PPLI is achieving that, and that seems to be fairly robust. Family office, as it stands and as it is, with just a shareholder, that would seem to be wide open in terms of the CFC coverage. Certainly Indonesia would be there. China, probably keep an eye out from what Michael's saying earlier. Right, we'll leave this bit and move on to consolidation. A little bit easier here. Really looking at, from a financial asset standpoint, is there any restrictions on the type of financial assets that can go into each of these different solutions? And then looking at the family business aspect, and particularly if there's any restrictions on the type of family business that can be absorbed within each solution, because clearly from a Southeast Asian perspective, most of the wealth is family business, and it's obviously transitioning. We're having family offices, you know, diversifying, but that's still a work in progress. We haven't got to a fifth generation sort of wealthy class at the moment. So looking at the financial assets, I think it's fair without much analysis that there isn't much to do in terms of differences between the two solutions, but looking particularly at the family businesses. Yannick, Roger, is there typically from a sort of life company perspective, how do they feel about operating businesses? Can we actually get operating businesses in absorbed beyond 5%? So in other words, can we put the whole thing in there? And are there particularly trades that they're going to be very leery of taking on, you know, like burning down a forest or something, or chopping down things, or trying to pull, you know, oil out of the ground, or anything that basically destroys our planet? So what's been the experience on that?
I think that one of the reasons why you know, we have 30 carriers in 15 jurisdictions is that oftentimes we can find a solution for the family and for the client. All carriers will take all types of businesses, but there may be one or two that may take that type of business. So we can be very flexible, and I think that's where where advisors like us sort of add a lot of value because we have that really breadth and that depth of in terms of the number of carriers and the scope that we can do. I think something else to really keep in mind is that, in terms of the only restriction I really do see is that in some countries there are foreign ownership restrictions. So in Thailand, for example, you can only own up to 49% of an onshore company. In Philippines, maybe 40%. Those are the only sort of restrictions, hard and fast restrictions that I really have to watch out for. Most of the times, in those cases, I can it looks like a foreign insurance company is taking over that company. So I can only go up to that limit. But otherwise, it'll be quite flexible.
Okay, and in terms of the way in which the life companies like the business to be held, do they want to have an intermediate regulated fund? You keep hearing about VCCs being used to sell out some of the family businesses. Is there a working practice that they try and be standoffish in terms of the chain of ownership, or how does that look from a practical standpoint?
It's a good question. I mean, it can be more flexible than that. So oftentimes, all we need is a holdco. You usually have an offshore holdco. It could be a VCC, it could be some structure in between. But oftentimes, an offshore holdco is much more efficient and much less costly to do. So just the onshore operating company, we put into an offshore holdco, take the shares of the offshore holdco and put into the PPLI.
And that offshore holdco doesn't have to be in any way umbrellaed under some regulatory environment. That doesn't seem to be there.
Yeah, it could be a pick from any jurisdiction. It could be a Singapore, a Hong Kong, even some of the British protectorates, a BVI, Cayman.
Okay. Yannick, anything from you, Yannick, on this point, enveloping businesses into a PPLI?
Yeah, I think maybe one point which has so far been forgotten is that for certain jurisdictions, it's not allowed to wrap up businesses, family-owned businesses. A good example maybe is the US, where you have control doctrine and diversification rules. So no chance at all to do that because you would need to give up the control and everything, and that obviously doesn't work, or otherwise the policy would be tainted. So such things need to be taken into consideration because obviously the product itself is an open architecture. But what we really need to look at is the regulatory environment in the jurisdiction where the client is living. And certain jurisdictions would allow more flexibility on the underlying investments and others less.
Yeah, I mean, in terms of Indonesia, presumably a PMA structure would be fine. You could wrap that whichever way you want, as long as it's got the clearance to be held by a foreign ownership. From a China perspective, have we got any experience of that?
So from a China perspective, typically it doesn't look so far that it's really regulated, that you cannot hold it. However, you should always look at it as at arm's length. So if obviously it then looks like that it's really kind of just a policy in between and it's not a real life insurance as it should be, you could cause issues with that. In the end, it's all about substance, like with companies and other structures. Here it's also about substance.
Yeah. The life companies that actually allow this, are they mainstream or are these boutique? I just want to get a feel for where you end up in the market if you are wanting to envelope a family business in this way. Does it end up with a major life company, or do you actually end up with a sort of special purpose kind of white label job?
I think it just depends on the carrying jurisdictions. So I think some of the European carriers tend to be a bit more flexible because they're used to these types of things. But it just depends on jurisdiction. It depends on type of business. I know people hate these "it depends" type of questions, but it really does depend in this type of case, right? Bankable assets, everybody can take. There's no issues with that. Anything with a family business, operating companies, we really have to look at it on a case-by-case basis.
Right. Okay. Michael, from the sort of single family office perspective, what's the view that we can have a concentrated ownership in a family business being the basis on which we establish a family office under these rules in Singapore?
I mean, certainly from the resident fund schemes, in terms of getting the tax exemption, it has to be what's referred to as a designated investment, and certainly shares in a company would constitute that. But obviously the 13R, 13X regimes, are fund exemption regimes. I mean, I haven't, I tend to see just, financial assets, portfolio assets in the structure. I mean, Wong Li, I'm not sure whether you wanted to add anything there. And obviously just a broader tax point around sort of, holding trading companies, within the structure. If assuming there's no, it's okay. I mean, in any event, you potentially have sort of significant tax costs with the transfer associated with that. Stamp duties, capital gains taxes, etc. But can be designated investment. But defer to Wong Li on the broader practical experience.
Right. Okay. Wong Li.
Yes.
From this perspective, looking at the, business families obviously are always considering ways in which they can structure for the next generation. And my experience is that they're quite happy to look at different platforms, and particularly where they feel that there's some level of advantage to the family, particularly cross-generationally. Have you come across any in your practice that actually have looked sensibly at a PPLI to envelope a family business?
Honest truth, no, not really. It's not an instinctive structure from, as you say, transgenerational to next gen. From a succession structure perspective, I tend to see it used more for sort of straightforward succession, where you have a particular asset that you want to pass to maybe one or two beneficiary upon passing.
Yeah.
When you have an operating family business, generally the management and ownership succession aspects are more complicated. So your insurance contract in itself, I think in theory, you can potentially draft it to cater to some of these governance aspects and transitional aspects, but it's not something that people naturally think about instinctively. I think that's a starting point. When you look at the family office structure, I think as its basic form, the succession aspects has not been, truly explored to its fullest, but everyone knows that this is the building block. This is the starting point, and then there's usually a placeholder. We look at it to deal with the succession aspects in relation to the fund vehicle from the ownership standpoint, and then from the management succession aspects, then you'll be looking at the governance aspect to see who's going to manage, who's going to control. So if you place your operating business within the fund entity, I think it is more natural to deal with some of these issues. Not that you can't use the PPLI, but it's just not so commonly used. At least I've not come across many. And Michael's point in relation to whether I see operating business being included in the sort of fund incentive scheme, not as a standalone. From time to time, we see that as Michael said, primarily financial assets, but clients do request that, oh, can I also include this in because I've got significant holdings on this aspect. So it's sort of like a combination, an additional asset on top of financial assets.
Yeah, I mean, certainly I've seen the emergence of the family office with family businesses. It tends to be that there'll be an enveloped family office, which means it will sit alongside as an affiliate.
Yes.
Not necessarily as the diagram at the moment
That's
shows
right.
the trading company underneath.
Yes.
Actually, it will sit alongside the holdco.
That's right. Yes.
Yeah, I think that's more typical of the scenarios at the moment. Is you'll have an enveloped family office, presumably absorbing some of the dividend income from the family business, and then ultimately looking at
We should do the family office.
Yeah, a liquidity event to then decant into a full-fledged family office. So that's the emergence. That's that I see.
Sometimes when I see under the fund is when the family, operating business is a listed company, and then they, they're not really managing very much anymore, but there's a good stakeholding with good dividend, and they sort of, leave it there as sort of part of the fund.
Yeah. Right. Okay. Moving on to the next one. Control. This is always quite a tricky one to deal with. So policyholder control, shareholder control. Okay. I think Yannick, Roger, just to explain to the audience how a policyholder effectively is able to exert some level of control over this investment company. And clearly this is going to be around the directors of that investment company. And one aspect I'd ask you to sort of mention is do the life companies actually want to have their own directors sat there as well? Or how do they effectively supervise or at least assess the risk level on these companies going forward? So from a control perspective on policyholders, how do they end up having the wiring effectively around the outside of these policies to end up being able to control the office of directors?
Can I take this one?
Sure.
No problem. So basically, as you pointing it out rightly, is there are basically two levels of control. You mentioned here the policyholder control. The policyholder control is actually that the policyholder has obviously all the rights in the policy, so he can change whatever he wants in the policy, beneficiaries, he can change the underlying investment, he can surrender the money, etc. So the ultimate control is anyhow with the policy holder. On the other side, if you use underlying companies like the investment company, typically the insurance companies themselves, they don't want to be the director. So they basically would say that there needs to be a nominated director, or sometimes maybe the client. However, obviously, as I mentioned before, in certain jurisdiction that is not well to do, because obviously nowadays you need to think about place of effective management as well, and so on. That creates obviously a whole other issue. We have mentioned Taiwanese CFC rules, that will be a topic there as well. So this could obviously cause a problem to the structure. Nevertheless, in general, it's an open architecture, so the client could actually decide who should be the director of the underlying company, and the insurance company would then basically purely act as a shareholder.
In that decision around the director's appointment and removal, that's embedded into the policy contract itself?
It's not embedded in the policy contract itself. It's typically through side letters.
Okay. I think from the shareholder perspective, it's just straight line corporate governance, the same issues that we would have with any company structure. If you're the majority shareholder, then obviously you get to decide the boards going all the way down, and you can exert your control in that way. So it's a straightforward approach from the sort of family office perspective, in comparison to the PPLI. Now, one particular wrinkle that I wanted to highlight was the case where if we have a policy holder passing away or losing capacity, but without it following into a insurable event. And I wanted to just chat through what happens to a policy where it's a sort of hung policy. Policyholder is no longer there, but it's not gone through an insurable event because presumably one of the life assured is still available. And so we haven't got a decanting over to the beneficiaries. How does that then play out from a policy perspective? What generally will happen, and what are the options that because presumably the life companies have anticipated some of this. How would we deal with this in practice?
Absolutely, that's a very good question, and actually quite a big topic, which I always see that a lot of people in the past maybe have that done wrongly, and therefore it basically causes a lot of issues. So two aspects, obviously. One aspect is if the policyholder, for example, is not the insured person, as you have also mentioned, if the policyholder would die, the policy would obviously continue to last. Now, in general, what you have to have is within the policy a regulation which says to whom it should go, the new rights of the policyholder or rights and obligations. If that has not been clarified, then actually the policy will be part of your estate, and the beneficiaries or your legal heirs will basically be the new policyholder, which can make things very, very complicated, as you obviously have, as you maybe have several legal heirs, and if they need to take decisions to change something, if you have 8 legal heirs, you can imagine it becomes very difficult to change things. On the incapacitated part, there typically, obviously, you need to have power of attorney for a third person. If there is nothing, then obviously you need to go through the legal process to appoint somebody who can now act on your behalf. However, we as 1291, we work actually a lot with something called an arbiter, which is like a protector in a trust sense, let's say it like that, where we have created this setup where the policyholder can appoint an arbiter, which has then certain rights to act if he's incapacitated or if the policyholder dies and the policyholder was not also the insured person, and therefore it continues to last the policy. And this actually solves a lot of those issues.
All right. How typical are these arbiter provisions in most of the PPLI policies? Is it something that's specialist, or is it quite a sort of pervasive provision that's in the marketplace at the moment?
So this is a setup which is not very common because only we use it, I would say. Therefore, obviously, it's not that common. But you usually also just use that if the setup is, you know, if it's straightforward, the policyholder is the insured person, you don't need to worry about that. Typically, where you use it is really if you have complex family structures. So I give you an example. We have a client, he has 6 girlfriends and 11 children with those 6 girlfriends. So there, as you can imagine, a lot of trustees wouldn't take on the assets because they would freak out about the situation, about the whole girlfriends and so on, where with the arbiter, actually you are able to solve basically this issue during his life, but also after his death.
Right. So I think the basic point is this: if you've got a policyholder passing away with effectively a hung policy because it's still active, then if you've not taken the time to provide enough within the provisions of the policy, the decision makers will be the estate. And then that may set you up for a fantastic contest if the beneficiaries and the estate beneficiaries are different people. Because presumably there'll be every incentive for the estate to surrender this policy as fast as they can be named as a new policyholder. I mean, that's the accurate result, isn't it, on having one of these hung policies?
Absolutely.
All right, Wang Li, have you seen this in practice? This sort of potential, loophole that we've got here.
The situation that you've described, where the life assured and the policyholder are different people, yes, it happens quite often, especially if the client is thinking that, well, I want to do transgenerational planning. You know, I'm very, very old. My children are quite old too, and I want to provide for my grandchildren, for example. They may sort of put their children as the life assured, especially if you're talking one of those with death cover. So it's cheaper to buy on their slightly less old children's life. Yeah. So I think from a scenario standpoint, this kind of situation does come up. So as you've rightly put, and Yannick explained about the arbiter arrangement and side letters, this is not typical arrangement insurance setup. And if the client is not using 1291 as a broker, a typical broker may not, as a matter of policy, has any, are not allowed to deal with side letters, for example, or they have no concept of dealing with side letters. So some of these issues are probably left out in the open and unsettled. And I have a question in my head, which I am not entirely sure, what's the answer myself, because as Yannick has mentioned, there are several powers that the policy holder has. He has the power to change beneficiaries, change assets, change whatever. Those are his powers versus his ownership rights in relation to the policy, right? So even though the policy is still an ongoing policy, he has died, this asset in theory should go to his estate. I can understand how the powers can be passed on to somebody he appoints. I'm not exactly sure how the ownership aspect can be dealt with this way. I don't have the answer. I'm just sort of raising it because, it's just not something that's commonly explored when it comes to a policy situation.
maybe if I quickly can come to this point, obviously the policy itself is theoretically out of the ordinary state. That's why you can name beneficiaries, and that's why you can transfer the ownership. The issue is just very often it gets forgotten that if you have different policyholder and insured person, a lot of people think, oh, I need to name the beneficiary when the insured person passes away. But here you have a second instance, or that can happen, that the policyholder dies before insured person. Usually within the insurance document, you can regulate it and you can say, okay, I nominate this person if the policyholder passes away before the insured person. But if you forget that, then it goes to the legal heirs.
Yeah.
Yeah, and then so this comes back. So only how, with junior wealth planners or inexperienced wealth planners, are they actually going to pick up this point?
My gut is that they're most likely to miss it.
Yeah.
And if you look at the sort of the Asian landscape when it comes to wealth planners, they're more familiar with trust structures than they are with policies. And if they are familiar with policies, they're more familiar with the jumbo policies.
Right.
So when it comes to these sort of more bespoke policies, they're meant more for wealth planning.
Yeah.
I think they need to pay attention. And if they need to, speak to the 1291s of the world to understand how can you sort of bespoke the policy a little, speak to the Michaels of the world, to get a counsel to come into the picture, to look at the documentation, to ensure that, it is fit for purpose. I think it's important because some of these issues is not typical. The scenario is typical, but, if you're not used to seeing how this works, it takes people some time to even think through, okay, what is the trigger event when it comes to policy?
Yeah.
Is it the policy holder dying, or is it the life assured dying? It may be something that we find instinctive, but for a junior planner, maybe not.
Right. Yep. I think looking at the shareholder, it gets a bit more easier. I would say, obviously, you're going to have the shareholder go off if the person passes away. You're going to have a probate, or if it's subject to local sort of civil law jurisdiction or Sharia, you'll have an immediate vesting in the estates. Incapacity, again, you'll have the same issue of trying to do potentially a cross-border sort of guardianship claim, and whether or not that's public forum as well will be an additional. The one I wanted to highlight on this particular scenario is if you've ended up with a single shareholder, single director structure, and the issue that you can have if that same person passes away or goes incapable, and the entire system then shuts down because you've got no lights on anywhere within this. I was just going to ask, Wong Lee, from your perspective, how many times are we seeing clients sort of rushing through this, ending up with single person entities with this dual risk of having no director and no shareholder at the same time?
Very common. So they're usually in a rush to meet all the 13X, 13R requirements. And I think it's also sensible that they don't rush themselves into a gigantic PTC and whatever structure that they do not understand. So the first step is just get a very lean structure in place to get the ball rolling. But I think it's important as the advisor to put a note to say, okay, once we've sorted all these applications and everything else, the next stage is to look at this structure and see what are the next steps to professionalize it over time.
Yeah.
So this is an important note that this is not, it's still work in progress. This is really the first step, and there are many more steps that they need to go with their advisors and their respective stakeholders to professionalize the situation with the help of advisors.
Right.
Yeah, just a question for Wong Lee. I mean, given the statements by the Minister of Finance and the press reports around potential wealth tax, which could take the form of an inheritance tax, are you starting to see people wanting to accelerate that next step? Yes,
the queries are coming in more, and the last two structures we were given very short timeline. They really want to sort of come in as soon as possible. So in the end, you're going to end up getting this piece out of the way first, then you look at the succession piece, then you look at the professionalization piece, and including the risk management aspect. So I think the takeaway for advisors is you get this stage out of the way, but that's not the end of the story. There's a lot more you need to do with the ring of advisors that you put in place for the clients to get the whole family office set up from strength to strength, so to speak.
Yeah. Okay.
A lot more work for Michael to do going forward.
Yeah. So from the privacy bit, I probably deal with this fairly quickly. The main privacy aspects will come up if you've got a sort of interspread of corporate entities using either British Overseas Territories, Crown dependencies, or the UAE. CRS is pervasive, so we'll have that going through. The key point to note, though, from the privacy standpoint is going forward in time, if you do have, let's say, BVI companies within the structure, and I think 13x from a family office perspective, you will have, if everything goes as it should, you will have the advent of publicly accessible beneficial ownership registers in the BVI and the other British Overseas Territories, which would mean that from a family office perspective, there is a privacy discussion that needs to be had with the client around using a jurisdiction that will go public. Not every jurisdiction will go public. Certainly from the FATF perspective, they're not requiring mandatory public registers as a global standard. They're not doing that yet. So, but if you are using the traditional Caribbean jurisdictions, you'll need to be aware, if you're planning these structures, that there will be public access to the register. Now, you may well have a Singapore company on top of this, or you might have a Singapore trust. These will all be sort of subject to disclosure on a public register in the BVI going forward. That's the public beneficial ownership. Economic substance can have an impact on this if, in effect, you're not arguing that the BVI company is tax resident in Singapore. Let's say you're actually arguing that it's tax resident in the BVI, then economic substance would be a consideration. Whether or not it's sufficient simply to keep the company in good standing, this is the fund company, or is going to be another issue, or whether or not you have to have staff and sort of premises, again, another discussion. If you breach economic substance rules, there's a spontaneous disclosure of the beneficial ownership anyway. Query all of this in the context of mainland clients, and whether or not the information flow into mainland China is going to be welcome going forward, particularly with common prosperity, and we don't really know how all that's going to be developing. From a CRS perspective, if you do the analysis, you'll find that the PPLI at least doesn't light up the beneficiaries life assured. It'll just be the policyholder that it's habitually looking at. Whereas when you look at the family office perspective on CRS, then it'll be all the shareholders going forward as the controlling persons. So on balance, what you end up with on a privacy perspective is PPI will come out slightly ahead, and the family office in its current state, probably, particularly if it's interspread with use of overseas territories, will probably have more of a privacy issue going forward than the policy. One query, though, is if you've got a BVI, let's say, within the PPLI, is a query whether or not if the policyholder reserves enough powers, whether or not that would be viewed as a beneficial owner going forward. And that's an open thing to how the rules will generate over time. Economic substance is not an issue, because if you do breach, it will just be the owners of the life company that will be effectively disclosed. Okay, so migration. I think this is a pretty easy smackdown in terms of the comparison. From a policyholder or shareholder perspective, obviously the single family office will confer sort of immigration rights into Singapore. From a PPLI policy perspective, you will not get that automatic right, as it were. So I think we're all agreed that that's the basic analysis on this one, that the migration aspect comes out ahead on the family office if you're looking at it from a Singapore perspective. And then the asset protection aspects. And here we'll look at two aspects, bankruptcy and divorce. Now, this is looking at it from the perspective of the policy holder is either bankrupt or going through a divorce, and what is the risk to the underlying policy in any of those events occurring. I'll preface it on two bases, that the policyholder is within the jurisdiction of bankruptcy or divorce, and then the policyholder is not within the jurisdiction, because obviously if you're within the jurisdiction, the court could make you do things upon pain of going to prison, right? So here we have a policyholder that's going bankrupt and or being divorced. So Yannick, any thoughts on this?
Sure. Obviously, you always need to look into the jurisdiction where you set up the policy. Different jurisdictions, they have different regulations. To give you a little bit of an idea, for example, the European countries who offer PPLI are the most known ones, let's say Liechtenstein, Luxembourg, Ireland. They typically have asset protection rules, where the asset protection rules are set up like, if you basically set up the policy to protect your legal heirs or your family, means your wife, your children and your grandchildren, then it becomes a non-seizable asset. And this obviously can give you a lot of protection. Let's say in the bankruptcy, the divorce case is something different, which I assume we will discuss later. Other jurisdictions have regulated it different. So Singapore, for example, if you set up a policy with a Singapore carrier, it expressively needs that you make an irrevocable beneficiary clause, basically. So you nominate your beneficiaries, name them, and it needs to be irrevocable. And a lot of people don't like to do that, obviously, because that actually makes it much more difficult to move the policy around, because typically if it's an irrevocable beneficiary clause in a policy, then whenever you want to do changes, the beneficiaries need to agree to all the changes.
Yeah. And on the bankruptcy, if presumably the policyholder can continue to enjoy the right to surrender?
Absolutely, but you need to see what the circumstances are. Obviously, first of all, there are fraudulent conveyance periods in all the jurisdictions as well. Europe typically has 12 months. There are couple jurisdiction in the Caribbean, they even have shorter, 3 months. And then obviously he still keeps the right to surrender, but obviously it goes back into his own estate, then it can consequently mean that he needs then to pay it to the creditors.
So the key bit there is that he shouldn't be in the forum of bankruptcy. So he shouldn't be in the jurisdiction in which he's effectively being bankrupt, because then he can be ordered to surrender.
Sure. Yeah.
Right. That's one of the key bits. Okay. And on the divorce side, do we have situations where any of the jurisdictions have rules that will not respect a sort of family court matrimonial order to split the policy or to surrender it out? Or do we have any of those provisions in any of the jurisdictions that offer PPLIs, that they will not recognize a matrimonial order from a court?
As far as I know, there is no jurisdiction which has such a provision. However, we have actually seen cases where this has happened, but they then based it on the asset protection rules, where they we had one case, for example, with the US. There was a divorce in the US, and in the US you typically have policy splitting. So you make 2 policies out of 1. However, the policy was in Europe set up, and the beneficiaries were the children. So the court actually treated this as the policy was set up to protect only the children. And since they were already divorced in the US, she was seen as an external creditor and therefore didn't get access to it. Also because this jurisdiction didn't know policy splitting. But it's I wouldn't bet on it, so I wouldn't use it as a sales argument that it protects anybody in case of a divorce.
Right, okay. But at least we have in the jurisdictions the asset protection from the creditor's standpoint, provided you're not in the forum, right? I think that's the key message. From the shareholder perspective, he's just wide open to all of this. There's nothing in the bland creation of a family office with an individual shareholder. There's none of this will be there. It'll just be subject to applicable law and whether or not it's there. Any comments at all from anyone else on this, or shall I move on? No? Okay. Right, reversibility. And this is a simple one, but I include it because it's, people do end up changing their minds. From a PPLI perspective, could we get out of this thing quite easily, or do we have massive penalties and trailing fees and God knows what else happening? Or is it just easily to reverse out whenever the policyholder wishes?
Yeah, in most jurisdictions, it's very easy to reverse these different policies. So I think the policyholder can simply write a letter. We can decant the policy usually within a month. We take the different assets out of the different policies. It's very, very flexible in that regard. And I think that's one of the reasons why a lot of families, especially Asian families, like to use these types of structures, because that flexibility that's sort of built into these PPLI policies.
From the family office perspective, presumably the reversibility is not going for the exemption, not maintaining the yearly spend or anything else. Michael, from that perspective, anything to say on, you know, the ramifications of not being enveloped within the incentive schemes?
Well, you would just kind of cease to qualify for the exemption, and then you're looking at the investments, assuming it's a Singapore fund vehicle, and identifying whether that, you know, income's revenue versus capital, whether it's received in Singapore, etc. But, you know, obviously, if you're looking to unwind the structure, you know, transferring out assets, liquidating companies, you know, not you know, takes time, particularly the liquidation process.
Yeah. Wong Lee, anything on you from the reversibility? Does it come up as a planning consideration at all? Is this discussed in practice?
Not really. I mean, PPLI is fairly simple to reverse, and family office, I think more often than not, we will raise it as an issue that, do you really want to do this? Because the setup cost, as we discussed earlier, is not low. It is something that you want to really think through and make sure you do it for the long term. So if you've done that piece right, the chances of them coming to the point of wanting to reverse, it will be in really extraordinary situations. And naturally, compared to the PPLI, it will be, there are more steps to do than just to surrender the policy naturally. But it's not, you know, it's not really difficult. It's just troublesome.
Right. Okay, last bit on the analysis, the back-to-back analysis, was succession. So looking at it from a PPLI perspective, and here we have the life assured passing, and then what would otherwise be a transfer across to the nominated beneficiaries. There's two aspects I want to discuss in this, which is the community property aspects and the forced heirship. Now, just to be clear for members that are watching, community property is the sort of regime that a married couple will have. And in this instance, we're looking at the policyholder having transferred a company into the policy. And if he was subject to community, half of that company ownership was his wife's, if he's in this scenario. So the question then comes up is, putting a community property into a policy, does that cure the community? In other words, does it effectively extinguish what would otherwise be the wife's half share? The forced heirship bit is all about this. This policyholder, or the policyholder had, we'll assume is no longer around, had originally constituted the policy with these assets. The beneficiaries are different from the forced heir beneficiaries that the policyholder would otherwise be liable to benefit. So the policyholder could be, let's say, Indonesian, or he could be a Filipino, some of the regimes that have forced heirship rules. Question is it possible for a disgruntled forced heir to effectively take action against some of these PPLI policy beneficiaries to say, look, that's part of my inheritance that you're getting from this policy, because what the what the policyholder did was contrary to effectively what he should have done under our domestic, let's say, Sharia law, or under our domestic civil law regime. So there's two aspects here, and I'd invite Yannick to have a chat through. First of all, is any of this stuff ever talked about, right? And if it is, what's the sort of answers here from the perspective of, here's a company, married couple, they're from a matrimonial regime, let's say China or somewhere, and they're transferring into a PPI policy, and no one seems to care that the wife may have a half share in this transfer. Is it typical that this comes up, and what's the result?
To be honest, I would say it's not so typical that it comes up. I also have not really seen any of the insurance carriers really taking any notice in that, or basically say, oh, if how is it? Is that only your wealth? Are you married? Basically, is it share property? Or there is one insurance carrier which actually we have just done, where they have the first time asked actually about the status of the marriage. Is it kind of separated estates or community property, etc. Right. But that's the first which ever came up. But I've also never seen any wife kind of trying to force her way in, I would say, into the policy so far.
Right.
Maybe there are certain other insurance carriers or broker I've seen that. I have not yet seen that.
I mean, from the forced heir, part of the trust side is even Singapore has anti-forced heir provisions on its trust law. And that's deliberately designed so that you can create trusts here that can defeat Sharia or can defeat civil law claims that would otherwise be applicable. But do we see the same with respect to the policies?
Absolutely. Obviously, you have regulations which say that the policies are out of the ordinary state. You can freely name the beneficiaries, etc. That is obviously then just in the jurisdiction. So you can set up the policy, you can choose whoever you want. Whether then the legal heirs have a claim against the beneficiaries in their home country is obviously a different story. They typically then probably can still go after the beneficiaries if it violated the forced heirship rules.
But they do have the firewall protections, the anti-forced heirship protections in the legislation around the policy. Is that correct?
Absolutely. So you as a legal heir, you cannot make any claim for the policy if the beneficiary clause in the policy is violating the forced heirship rules. The insurance carrier will not be interested in that. They will just distribute to the nominated beneficiaries.
So the one that's open is the community property on the married couple and how that will work out, particularly if the policy pays out to effectively just the children. So there's a potential there, particularly if they were married at the time when the property was put in, and then later divorced, etc. Okay. I think from and I'll come around to the panel after that on this bit. From the perspective of the shareholder, wide open. If there's community property and it's a common law jurisdiction, they'll respect that. If it's from a forced heir perspective, if you've got a non-domiciliary from a Singapore perspective anyway, let's say Indonesian or Philippines or China, then yes, China won't have the forced heir to the same extent, but they will respect that applicable law going forward. And that's key thing is that the fact that you have a Singapore single family office doesn't mean that you're not importing in other applicable laws. Wong Lee, from your perspective, just looking at this succession aspect, do we feel that there is enough mention and discussion around the community property aspects when it comes to policies and also the forced heirship? Is because I know in the trusts we'll do that, right? The industry will do that. They'll have enough training to have done that. But when they're dealing with policies, do you think that's another one where it's completely lost, this discussion?
I agree. As Yannick said, this issue doesn't come up that frequently. In fact, it hardly ever comes up. So when it comes to using it as a succession tool versus using a trust, some of the things that we normally think through, it doesn't really happen when it comes to an insurance solution. You tend to treat it as buying an insurance contract and entering the contract. Some of the issues in relation to how you fund it, you may think about the taxable event on funding, but you don't think about the spousal consent issues and things that you've raised. So it is a good takeaway for the other wealth planners here that when they use a tool like this that we're less familiar with compared to a trust structure, some of the issues that we typically will consider when we are funding a trust, they have to do the same and involve advisors to support them on this one.
Roger, Michael, any final comments on this one? No? No? Okay. This was what we came up with. I say we, not me, but I think these guys will support me, okay? This is a crude diagram, which actually sets out, I think, the narrative of what we've said, which is on the cost side, PPLI will look as though it comes out ahead, although with the caveat that the more you put into this thing, the more expensive it gets, so it'll at some point flip over to a family office. Consolidation, assets, etc., looks as though there was neutral on that. Control, PPLI was a bit complex about how it went about doing this, and there was a number of issues around, potentials for it to be a sort of hung policy. So the family office tended to be more straight line. Privacy, PPLI ahead, principally because the family office was just wide open for all of these reporting, particularly if you're using a BVI on your 13X. Migration, well, PPLI has nothing to offer, family office does. Asset protection, PPLI had a lot more protections built in, the family office had none. Reversibility, neutral. And then finally succession, I think PPLI came out ahead because it had at least the concept of a beneficiary transfer built in, whereas the family office, you take your chances with an intestacy or God knows what else would happen in the applicable jurisdictions. At least with the PPLI, you had some level of control. Now, given that PPLI comes out ahead, there is the caveat that it's horses for courses. So it depends on the type of client and what they're actually trying to achieve. Okay. Any comments from the panel at all on this?
I think for me, the succession piece, we need to remember that the family office, as we've discussed earlier, is at its rudimentary stage.
Yeah, it's half a
Most
structure.
of the time you have not, actually thought through the succession aspect. So.
Yeah, exactly. In fact, if you wanted to claw back on this, you would have to use a trust. So you could start to normalize the family office if you started to use a trust, and all the deficiencies will start to be manageable. Not all of them, but at least it will start to claw back. All right, moving on to the combination structures, last part, this shouldn't take too long. First one is family office holding a PPLI policy, and then the second version of PPI policy holding a family office. This is what it looks like in combination. Here's the family office above, and as part of the fund company investments is a PPLI policy. Let's assume that policy was effectively assigned in to the fund company. So questions being asked on this one. So I'll just bring it up. So there's the questions. It's the same list of queries, just at this stage, just which are the ones that we should be particularly concerned about? Looking at, let's say, for instance, the tax side. The tax incentive presumably is not going to be affected by this. But from the policy perspective, do we have, let's say, a break in the CFC analysis? How does it work, Michael?
To the extent that you've got non-resident owners, shareholder, and taking Indonesia as an example, the policy would be an asset of the fund company, and the CFC rules kind of look to attribute the income of that entity, based on the reported accounting profits. So to the extent that, subject to subject to the accounting, yes, it would still kind of, the policy would be reflected. It wouldn't sort of, doesn't break CFC attribution.
And you feel that's both for Omnibus Indonesia as well as the emerging rules in China?
Well, I mean, Omnibus Indonesia, then, then you sort of got broader questions around, what your distribution strategy will be, dividend re-exemption. But I mean, just in terms of, the value of the policy, depending on how it's accounted, it would be reflected in the prima facie CFC attribution.
Right.
Yeah.
How typical is this type of scenario in practice? Wong Lee, have you seen this type of structure being used habitually?
No. I mean, I'm struggling to figure out what's the purpose of the PPLI below, unless there's some, some tax angle we're looking at in relation to the underlying assets. But if you're looking at from a Singapore perspective, your fund incentive schemes, we have covered the Singapore bit. So is there some offshore aspects we're looking at in relation to the underlying assets? Is there a holding tax angle or something? So I'm sort of trying to figure out, what are we trying to do here? Or is it just a wealth planner trying to sell two products?
It could be that actually what they're trying to do is get the immigration status, but trying to be clever around the CFC. By having the policy.
Well, they obviously haven't spoken to Michael and got his advice because it doesn't help from the CFC standpoint. So
because your ownership is still
exactly.
So you've still got a CFC, right?
So we're saying that the cash value fluctuations will give rise to what, a nominal gain.
So subject to the accounting, right? And bearing in mind, taking Indonesia as the base case, I mean, the attribution depends on the accounting profit per the local accounting standards. So if it's a Singapore company, how would Singapore GAAP, accounting standards, look to reflect that? But if that is reflected in the profit, that's the amount that would be, subject to, prima facie attribution. Subject, Zach, as you said, to okay, what's our distribution strategy? Do we look to take advantage of dividend, reinvestment exemptions, etc.
Yeah, yeah, okay. All right. Anything else? Yannick, anything? Roger, anything on this one?
Maybe quickly from a practical standpoint of view, I have maybe seen that once in my past 18 years in the PPLI world,
Okay.
or maybe 2-3 times. And there is basically just one base case, I would say, where it's about saving withholding tax. Lee has mentioned it before. It was a good kind of.
So I made a good guess.
Because obviously there, depending on the fund, can he reclaim or not? And then with whom do they have double tax treaties? So if it's Singapore doesn't have double tax treaties with the US. So potentially if you have a lot of US investments underneath and you need to sell withholding tax, then there could be applicability.
You agree with that, Michael?
Yeah, I can see that. Yeah.
Okay, very good. All right, next one, last one in all of this. Now then, this is a PPLI policy that holds a family office underneath. This must be quite a rare bird in practice. But anyway, this is the scenario that we'll analyze. I suppose the question that would be asked is, are you still going to get your investment migration aspect to this? Are you still going to be entitled? Is this, in other words, is this a single family or is it a life company based in Luxembourg? That's the question on this family office from a Singapore perspective. What will MAS make of this? Any comments?
I think we're all looking at Wong Lee.
Well, I've not seen this before. I'm
Yeah.
not sure what MAS would think, but
Yeah.
in theory, if you look at it, it's not very different from your holdco being held by the trustee. You know, so to some extent, so you obviously do have to establish and prove to them that you have a common policy holder and
Yeah.
blah, 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 blah. We need to test it to see how they react. But I think it can potentially fly.
Yeah. Roger, anything from you?
Yeah, I think some of the preliminary discussions we had with some advisors that you know MAS would sort of see through that and they would see the ultimate policy holder. There would be the granting of the employment passes.
Right.
And it has not been tested yet, right?
Yeah. But if it were to happen, isn't this the ultimate structure then from a CFC perspective? Aren't we having literally the cake and eat it? And I hate using that term because I generally hate the people that use that term. But isn't this it? Isn't this the right structure then to try and have a go on if you want to have deferral as well?
This you get the best of both worlds, right?
Yeah.
There's a question around. I mean, you know, typically the single family office, you know, the management company, you know, relies on being exempt from licensing.
Yeah.
And, you know, I guess, you know, defer to you, Zach and Wong Lee, but, you know, kind of question, you know, how that exemption, you know, the availability of that exemption in that case. But yeah, otherwise you've got, you know, the policy, again, take Indonesia, say as a base case, you know, if the policy is not a CFC, you know, you've otherwise got deferral, you know, within the policy. Yeah. I mean, kind of give it a tick.
Right. So
at this day and age, I think that, you know, it's neither either or anymore, right? It's always a combination of structures, right?
Yeah, yeah.
Combination of the PPLI and the family office, or PPLI and a trust, or a VCC. It's a combination of these different structures now because it's such a complex world. Right?
Yeah, yeah.
One only be lifting and it does its own thing.
Okay, so the key one on this is if you are able to get the investment migration aspect and the work permits and all the rest, then you would get, you would have quite a powerful combination there because it gets the tax side, it gets the, I suppose the cost is under control, and then you also have all of the add-ons that the family office would bring.
Okay, so yeah, I guess just, you know, subject to the point that, you know, if there is that migration aspect, you know, and policyholders resident in Singapore, you know, versus say Indonesia, you know,
yeah, yes.
But if you know still wanted to have or did have, you know, an owner in Indonesia, an Indonesian tax resident, yes. But I mean, if everybody's migrated to Singapore, then
yeah. Okay, good. Right, that was the sort of end of the main discussion. We've got a number of questions now. Let's see. I'm going to look at so the questions are both on the Q&A as well as on the chat. So let's do the Q&A first. what jurisdiction is typically utilized for the investment company on a PPLI setup, and does it matter? So looking at the, your Investco at the bottom, where would that typically be? Are we talking about BVI, or are we talking about Midshore Singapore, or what do we typically see on this one?
I mean, I think it can be quite flexible, right? So you can see everything from, as you said, the BVIs and Caymans, which are now, I think under increased scrutiny, but also Singapore, Hong Kong, Cyprus. It could be any number of different types of companies and structures, right? Whatever you feel most comfortable with. But we do see, I think, a trend away from the classic sort of offshore structures. You see people moving away from that.
Yeah. Okay. I think one question on whether or not the PPLI family office are in a trust, would that facilitate succession asset protection? I think that's a key one. And I think what, sort of what we've been mentioning sort of throughout is that the family office, without looking at a trust, is half a structure. And that in many respects, the PPLI, without looking at a trust holding that, maybe not as half a structure, maybe, I don't know, a quarter, right? But certainly the family office without a trust would be quite bare. And it does expose a fair amount of weaknesses. The succession asset protection is some of the key ones, right?
Yes.
Okay. One for Michael, rather convoluted. For the cash value of an insurance policy to be included in the computation of assets of a fund co that is managed by a single family office, is there a requirement that the policy must be issued by a Singapore carrier?
Not that I'm aware of, no.
Yeah, okay. All right, that's that. And then the chat side, what jurisdiction is typically utilized for the investment? Oh, sorry, that's me repeating myself. Okay, here we go. Some from our experience, this is a rather chatty one, at Crown Global Insurance Group, plug, PPLI does not compete with and is not an alternative to a family office or trust. Okay, I think we can probably stop there. Do we get a copy of the presentation? Yeah, copy of the presentation and the recording and the slides. So another one on such policy should be held by trust, agreed. We think that the structures are half without that. Singapore irrevocable nomination can be revoked if policyholder appoints a co-trustee. I don't, has anyone, if you picked up on that, Roger? A Singapore irrevocable nomination can be revoked if the policyholder appoints a co-trustee. Is that a thing? Or is that?
I'll have to look into it.
Yeah, okay. Yeah, and I think that's pretty much it. Yeah, that's pretty much it on the questions. So usual admonition that everything we say you can't rely on, and it's probably full of errors. Otherwise, I hope you enjoyed this webinar, and I'd like to thank Wong Lee, Yannick Hani, Roger Chi, and Michael Velton for helping very much to go through this. And I think that's our VRT for today. Thanks very much for everyone that's tuned in to watch this. And there'll be more VRTs this year. Not quite sure how many, but they'll be of this technical nature where we compare different types of solutions. Okay, thanks very much, everyone, for joining us.
Bye.
Bye.
Bye.